which is otherwise not prosecute material, which is not within the criminal justice dictates, somehow is going to find a way now to advise how that is going to be done, and all of that. So, Chair, I don't want to waste time here. I just want to conclude by saying, for us as the MK party, we want to just put on record that if by end of this meeting that Advocate Batoy does not voluntarily submit her resignation, we want to confirm in this meeting that as we close this meeting today, we would have approached the appointing authorities to start the process to remove Advocate Batoy. I think enough is enough. Thank you, Chair.
Thank you. Okay, I'm going to pose a number of questions as well, but my questions are going to be in the context of Section 22, subsection 1 of the NPA Act, which actually gives an authority to the NDPP as a head of prosecution to exercise all powers and the performance of all the duties and functions conferred, imposed on or assigned to any member of prosecuting authority by the Constitution. And I'm going to ask some of the questions in the context NDPP of Section 22, subsection 4D, which actually gives upon you a responsibility and a power to assist the directors and prosecutors in achieving the effective and fair administration of criminal justice. But I just want to check maybe, please provide a quick answer here, because everything else is dependent to what would be the answer. NDPP, have you ever made an effort to meet with the DPP of the Eastern Cape together with the prosecution team in the Omotoso case? NDPP? Members, can you hear me?
We can hear you.
Sorry.
Sorry, my apologies.
Okay.
Yes.
Can you just take that one?
Sure. In this particular case, I did not meet with the DPP or the team, but of course, had the DPP requested or brought certain things to my attention, then I could have decided on what a national director should do. But in this particular case, the DPP was dealing with the late Advocate Rodney de Kock, and regrettably, no red flags were brought to my attention, so that did not happen.
Okay. No, I'm asking you specifically NDPP because the National Prosecuting Authority Act refers to you, the national director. It does refer to deputy national public directors of public prosecution. But these two sections I'm talking about refers to you as the head of the prosecution authority.
Yes, and the NDPP delegates certain functions to the deputies.
We'll come to that.
Sure.
Now, there is a need coerced by circumstances for a change of the prosecution team. Now, the DPP presides over the process of ensuring that the prosecution team is changed because there are coercing circumstances that warrant that the prosecution team must change. But still, you saw no need. You're going to come back on all the issues I'm going to raise when you come for responses. But still, you do not see a need for you to go down in adherence of these provisions in the NPA Act and assist them, understand their challenges, so that you give them the necessary support and so that they have the necessary capacity to proceed with the case. DPP, maybe this one will be very relevant to you. Part of what is being said is that part of the statements the complainants have made was that they have made numerous attempts to the SAPS to report sexual abuses, but they were turned back by SAPS that they must go back and resolve these matters in that particular church where they are actually abused. So have you been able to help the victims in that regard so that they report where they are supposed to report that kind of the conduct from members of the SAPS? Honorable Mhlongo raises a very, very serious matter here of advocating Ntelwa. Whether he is still in the employ of the NPA, are we paying the remuneration and benefits to him? Is he suspended or not? If not, let me go to the if not. If not, what is it that you are actually waiting for? What kind of evidence are you looking at? If even a court judgment, unless you are actually doubting the court judgment itself, because I think even the factors of law that you are appealing on have nothing to do with what the judge says about the conduct of advocate Ntelwa. Now, the judgment goes to an extent of saying the lead prosecutor subordinate complainants in committing perjury. Now, let's go to a simple explanation of subordinate, honorable members. Subordinate, in terms of the definition in the Oxford Dictionary, the simple says bribed or induced to commit perjury. So if you have not acted against the then lead prosecutor, what is it and what kind of evidence that you are waiting for you to act and be able to enhance consequence management in this matter? Look, this matter does require serious consequence management. And I think it is indicated in the report that Advocate Berima Dolo would have reported this matter in 2024 in the labor unit in the NPA. I'm not sure if the statement you issued does not bring any progress report in respect of what Advocate Madolo reported in 2024. Was Advocate Madolo reported in 2024, while in May 2025, the statement just says the NPA is going to proceed with the investigation that was started by the labor unit maybe in 2024. So maybe also as part of explaining the consequence management that we are going to undergo, explain or rather update the committee and the public on the issue of the progress report since the reporting of Advocate Berima Dolo in 2024. Look, there are a lot of issues that the judgment itself is outlining to us, which include that the consultation by the lead prosecutors, soliciting statements from the complainants, and the statements that were solicited by SAPS were contradictory. And if this is the case, NGPP, do you not think that, have you taken time in adherence of Section 22 to go attend and get closer to the team or any team that is handling a high-profile matter? These some of the matters that are raised in the judgment would have been prevented before they happened. issue of the irregularities that are pointed out in the judgment itself, had you gotten closer to the team, including the DPP and the prosecution team specifically for this particular matter, do you not think that these matters would have been avoided had you been closely monitoring this situation, not only this situation, other situations that are involving high-profile case matters? We won't count them. The complainants, NPA themselves, made an indication to you that they no longer feel safe and trust the team that you have bestowed them to lead their complaint in court. And they've indicated that through writing a letter to you. And still, you have not seen a need for you to get closer to the situation. In adherence of Section 22, subsection 1, Section 22, subsection 4D. There's a letter written to you. It's an unusual process. You have complainants that are in court. The DPP sends a team that he trusts to deal with the trial. But in the course of the trial, the complainants, because of their dissatisfaction, so write to you personally as the National Director of Public Prosecutions to attend to a specific matter they are not happy about, and still you did not see a need to get closer to the team that is handling the matter. And it is my belief that had you gotten closer to the team, working closely with the DPP, you would have easily seen that there are some of the witness statements that were concealed by Advocate Ndelwa. You would have picked up that already Advocate Ndelwa is acting unethically by going to an extent of opening a WhatsApp group between him and the complainants. And part of makes it more suspicious is the fact that those messages that were communicated in that WhatsApp group are now deleted. Look, it is my, the judgment is actually scathing. It goes to an extent to say, the judge says actually, Mr. Ndelwa doesn't understand the definition of rape. That's what the judge says there. And in my view, NPA, had you been closer to that situation, you would have picked up the weaknesses of the team that is tasked to attend to that very critical trial. 14 years of experience, that's what the judge is saying, with a person who's struggling to understand the definition of rape. So my view, I'm trying to display to you, NPA, that you have failed as the NPA to get closer to the situation. Had you been able to get closer to the situation in accordance to this act? And I hope you won't pass the ball to another person, because the act refers to you as the NPA. I'm sure you'd have picked up some of these weaknesses and be able to reinforce or change the team working with the DPP. There is no doubt that at this particular point, we all agree that we failed those victims. And we were given a second opportunity to recover the lost ground. And with the hope that we won't mess up this particular issue. And it is in my view that had you been in adherence of what is said in the Act, you would have picked out that the team does not have a necessary capacity, such to an extent that they were even unable to do an adequate cross-examination. And my view is that, as the member of parliament, is that had you been closer to the situation, as the Act directs you to, you would have picked up part of these weaknesses, and some of them would have been avoided. In 2023, a letter is written to Advocate Digog. It's written by the DPP, reporting about this thing. In 2023, NDPP. And it is my belief that in such matters, the Deputy National Directors are unable to act without consulting you. 2023, the DPP in the Eastern Cape writes to the late Advocate Rodney Digog complaining about the misconduct in this trial. The judgment is handed down in 2025, April, but still there is no action that had been taken to avert this situation. It is in my view that by failing to take drastic actions to attend to what the DPP was raising, would have at least averted some of the issues that had been raised by the court against us. So, and I'm not sure, maybe take us through NTPP. Why is it still the DPP of the Eastern Cape that is appealing this judgment? Why are you not taking the matter of the state versus Omotoso criminal trial to your hands? Why is it not sitting on your table so that you yourself, in accordance to this act that governs you, you lead the most capable team to go and argue evidence in the Supreme Court of Appeal? Why is it still residing in the Eastern Cape? Maybe let's pass the judgment now. We have got a Criminal Procedure Act that limits you in terms of the circumstances where you can appeal an acquittal. You are here in Parliament now. What do you think Parliament must do in assisting the prosecuting authority in trying to strengthen their powers in terms of the appeal on acquittal issues? In the review of the Criminal Procedure Act, how do you think we must be able to assist the prosecuting authority in that regard? The defense, honorable members, Advocate Madolo, the defense immediately after the state closes its case simply runs for a Section 174 application. That, in my view, was indicative that we have a problem. Was it would have been an indication that although the judge was on our side as the state, but it would have been an indication that there might be some things that had been picked up by the defense that we were not able to prove our case when we were arguing our case at the state. So I'm trying to display a series of events and DPP that which would have, in my view, awakened your conscience to get closer to the situation as the trial proceeded. We say we are proceeding with an appeal against the judgment of Judge Skuman, but say we're going to file our papers within reasonable time. And I've got a problem with the wording. And I'm sure the wording, Advocate Madolo, was chosen very carefully. This matter is a matter of a serious societal interest. There is no doubt amongst all of us here that this matter must be expedited so that we're able to see justice being done. So saying within a reasonable time, we don't know what is reasonable in your own understanding. So if you can tell us that in terms of your turnaround strategy on this matter, what do you mean when you say reasonable time? Because as things stand now, as we are presiding over some of the experiencing some of the delays and the problems, it does look like even 5 years can be reasonable in the NPA. So what is this reasonable time? Tell us. In terms of your strategy and your plan, you expect that at least by this particular time, you would have filed the papers in the Supreme Court of Appeal. DG, I'm not quite sure if you are aware or you have been mandated by the minister to brief us on the Section 33 report that she has requested from the NDPP. What did the department pick up? How did the department try to prevail in this situation? And how far now are we, DG, with the review of the Criminal Procedure Act? And one thing, NTPP, that I'm going to commend the NPA on, and it's one thing, trust me, it's one, is the communication. It has drastically improved. You are able to keep communities and the people of South Africa abreast on what the prosecution is doing, where it is finding challenges, and where it is winning some of the cases. And in that, I commend you, NPA. You are doing very well in that. One question to Advocate Madolo. Advocate Madolo, what is your impression about Advocate Ndelwa? Do you think that he deliberately sabotaged the trial against the state and against the complainants? What impression do you have about his conduct, his theatrics, his incompetence, his uselessness, and everything else? Look,
should I respond?
No, you'll come later, Advocate Madolo.
Oh, okay.
At least you have got a better video now.
Thank you.
Look, there's no doubt. There's no doubt. I think another member was asking about how do you think this will impact the criminal justice system? And I can answer, honorable member, I just forgot which one was. The impact of this mess is people of South Africa losing confidence in the South African criminal justice system. And by that, taking the law into their hands. And by that, we'll be required to go to the communities and talk to those people. And at the time when we go there, they will no longer be listening to us. Nor will they be listening to any authority of the state. And the country will become lawless. And that's the situation we must always fight, that this country must not become lawless. So thank you very much, members. Let's allow now the team. We'll start with the NTPP. We'll take the DPP. We'll take Advocate Boni. Then we'll take the DG or Advocate Pile.
Thank you, Honorable Chair. There are one or two other NPA colleagues that will need to respond with regard to other issues relating to the matters in respect of disciplinary matters, etc. But before I hand over to colleagues to deal with questions, and then I'll come back at the end, and to just ask that the DG also deal with the question relating to whistleblower protection. So, Chair, not surprisingly, we have come under serious criticism and attack in this session today. It's understandable because of what has happened. I expected that, there will be very hard questions, and they have been. I just want to reiterate one or two things. And Chair, maybe to clarify on your last question so that when we answer them, we are on the same page. Just to understand, you asked a lot of questions about my intervention, and that things could have been different had I intervened. I want to ask for clarification. Is it the Chair's understanding that Advocate Ntalwa is one of the prosecutors still in this matter, and in fact prosecuted the matter until the end?
No, I know they had been changed.
Okay,
that's why I was asking. That's why I even said my first question was that the first team was changed and a second team was put forced by circumstances. And my view is that you should have started getting closer to the situation.
Even with the second team?
Yes.
Okay, I'll deal with that. So, Chair, firstly, let me make a few comments, responses to some of the comments that have been made. Just to say that we framed our presentation in this way, that is dealing very specifically, and we were not aware that the expectation was that we will go back in time. We understood it to be, what are we doing to address the impact and the consequences of Omotoso decision? And that is how it was framed. But what we did is we dealt with all of those issues, the three key interventions. But the reason why we also included some of a fraction, a small, minute fraction of the really good work that is being done by prosecutors across the country, who I would ask not to be demotivated by this session. The reason why we included this, it wasn't to get any applause for it. It certainly wasn't, to sugarcoat the devastating impact of the Omotoso decision. That was not the intention. The intention was really, we understand that the Omotoso decision has dented confidence in the criminal justice system. And the reason why we thought it's important that we deal with these issues is that many of the honorable members raised the fact that people lose confidence in the system. Victims may not come forward. And the reason why we included all of this is really to appeal to victims. Don't throw the baby out with the bathwater. This is a very important decision. It has had a devastating impact. And more than that, the victims, of course, feel it more than anyone. As the NPA, we feel it because of the impact on the institution. And so because of that, we wanted victims to know, which is what I said in my opening address. We are saying this because understand this is one case, but a very important case. But please don't lose faith in the system, because there are so many good things that are happening in the system. And that if you happen to be a victim in the future, please don't be discouraged by this one decision. Know that you will get the necessary. Firstly, know that we are ensuring accountability, and we are, with regard to the three interventions that I mentioned, but also know that you will get world-class service. which victims across the country are getting in many Thuthuzela care centers, but also there's many support services in places where there are no TCC. So I really want to urge that the idea was not to sugarcoat. This has been a devastating decision, but it's really to say to victims out there, please don't underreport. You do nothing wrong. Come forward and report these matters, because you will get the services that you need, the support that you need, whether it's legal, psychosocial. You will get these services to make sure that at the end of the day, justice prevails. And that was the only reason why we did this. It is not to receive any applause for it, but to really give confidence to the victims that don't lose faith in the system because of this one case. There's a lot of good work and hardworking prosecutors that will support you and help you get through to this process to become a survivor. So that was the only reason why we did that. And we still think it was important to have done it. We would appreciate perhaps if the portfolio committee wants us to come and do a separate presentation on all of those things, which it was the tip of the iceberg today. We are happy to do that, to build more confidence in the system, which has been badly dented. So I think I'm going to, at this point, call on perhaps Mzanyati, can I call on you? Should we go to Barry Madolo first to deal with? Perhaps, Barry, I think it would be best if you deal with some of the matters, and then we'll look at what still needs to be covered. Can I hand over to you, Mr. Madolo?
Good afternoon once again, Honorable Chair and Honorable Members, NTPP. I'm trying to check, where to start, but let me go on by start by saying this. I got on board, on this matter, and I'm responsible for the last team that dealt with the Omotoso matter. And in terms of their experience, they are seasoned prosecutors, and the lead prosecutor being a senior deputy director of public prosecutions. We managed, to have Advocate Ndelo removed from the case. And then this new team took over and proceeded with the matter. And as they were proceeding with the matter, we kept on meeting, having regular meetings with them. When I say we, I mean myself and them, just to check what was going on, what problems were they faced with. And there were many problems regarding the mistrial application. Besides the 174s, there were mistrial applications. But we also had a safety net that was there, which I found already in existence, whereby there was private counsel involved, about 3 counsel involved dealing with the mistrial applications and giving advice, to the prosecution team. But what happened is, regarding the Ntelwa issue, I did say there must be an investigation. And I reported this to Advocate Rodney Cook. But already when I took over, there were other problems that happened before I took over. But I picked up that the problem here was not just Ntelwa. There were issues about leaking of information, internal emails being sent out, and all that. So I said, maybe let's have a broader investigation to find out what exactly, is happening in the matter. We agreed with Advocate Cook that investigation must be done. But I must confess that I said, look, we don't want to take these witnesses, have them interrogated about the internal investigation before they testify in court. Let's let them testify And then thereafter, when the state case is closed, and then we can continue with the investigation. But that investigation has continued. In fact, last time I checked, there was an interim report on that, but the team had to be beefed up. The NPA already dealt with that issue. Then we pushed the case to the close of the state case, which was also a milestone for us because if one has been following this case, you'll find that it has had many interlocutory applications along the way. You know, it's been to the SCA, it's been to the Constitutional Court. It has a long history. But after the 174, which you mentioned earlier, there was also another mistrial application which was dealt with, and we succeeded there. You know, that is the 174 and the mistrial application. Now, coming to the issues of poor cross-examination and all that, my view was, let's just have a look again at the record, because I would be very disappointed if these seasoned prosecutors were not able to cross-examine, you know, Omotoso on essential issues. And that is a subject of an investigation right now. But the other issue was the change of the prosecution team was not easy. Not easy in the sense that Advocate Ndelo had already built a relationship with these witnesses. And they found it difficult to proceed with the new team because, you know, this is a sensitive matter. They had already had consultations with Advocate Ndelo. So it was not easy to transition, you know, between Ndelo and the new team. But we managed that, you know, until there was a smooth transition. And the new team built a relationship with the witnesses, which, you know, took us to the stage where the case was finalized. We accept that, you know, the case didn't go well. It didn't go in our favor. And we, on the other hand, let me say on the other hand, still I'm of the view that we appeal this matter, which we are doing now. And I don't want to preempt what the outcome of the appeal is going to be. But as a DPP, I am sort of confident that we have enough grounds to appeal the matter. And if I must, you know, if I can just go back to the Ndelo issue, Chair, you asked me a question about Advocate Ndelo. We've removed him from the case. He's still working for the state. We've had to take away some of the work that he's doing and reallocate it to other prosecutors because of this, you know, investigation that is still hanging over his head. So that is the position now regarding Advocate Ndelo. So he is still on the NPA payroll, and also the three prosecutors that finalized the case that took over from Advocate Ndelo are still in the employ of the NPA. There's a separate investigation that is taking place regarding the comments made by the judge about them. And Land Labour is also working on that issue together with the ethics office. The other issue is the whistleblower that, you know, was killed. The police are working on this matter. You know, we are aware that the suspect has also been shot, but he was just a suspect at the time. But we will once again check with the police how far they are with that investigation. And again, if I must deal with the delays in finalizing this case has a lot of history. and a lot of, applications took place along the way. And even the changing of the teams of prosecutions also affected the progress in the case. But when I assigned this new team, I said to them, look, this matter has been going on for many years. Please push it to finality, and I think they did their best to have the matter finalized. But we are appealing the judgment, Chair. We coming to what is a reasonable time. There is a team that's been assigned to deal with the appeal. I think they are on board here today. I think they can give a clearer picture. But I have made a decision to appeal the matter. There are papers that have already been filed, towards that appeal. There's still a lot more that needs to be done, in the matter. That is to make sure that the appeal gains some traction. Then there are other legal issues that we need to deal with, But Chair, I accept criticism. If my people, that is the last group now that I'm talking about that dealt with the Omotoso matter. I picked them based on their experience. I picked them based on them having won many cases of a similar magnitude in the past, And if in this one they have bungled the case as it is alleged, and their cross-examination was very poor, I'll take responsibility for picking that team, because I did not just pick anyone. I picked people that I thought were capable of dealing with the matter. In fact, the first advocate that I put on board was Advocate Ntlakaza, which was now, I think it was around December 2021. And then 6 months down the line, he had to step down, for other reasons, which are internal in the NPA. And then I brought in 3 prosecutors, a senior deputy and 2 senior state advocates that have years of experience here. So if they bungled this matter, I must say I would be disappointed, because this is a group that I trusted. This is a group that has experience. As for Advocate Ntelwa, you asked me what do I make of him, which is a very difficult question, because the matter is under investigation. But my prima facie view, I don't want to go into details for a matter that is still going to be appealed, and there are internal investigations. But there are certain observations you make about your people, and one of them is there are people who are just not team players. They would want to work alone, and not want to share information. And unfortunately, Advocate Ndala is in that category. But that is a matter that is subject to an investigation. I don't want us to dwell on that. But I want to reassure you, Chair, and the committee that we going to expedite this, the appeal. But I think the members of the NPA that are part of that appeal process are here. Maybe they can elaborate on that. Again, Chair, like Honorable Musala, sorry if I'm pronouncing that wrong, I heard her sentiments, and I sort of want to align myself with her sentiments, but I don't want to say much about the judgment, at this stage when the matter is as good as being sub judice. So I think that will be my input here. And I don't want to come here with excuses. I put a team that I thought was the best team. If I add there, then the investigation will tell me that I add, you know. And whilst they were busy with the case, you know, I was with them, I walked with them, you know, to the extent that at some point they introduced me to the witnesses in the matter, and I wanted to make sure that there's rapport between them and the witnesses. And at that stage, I was happy because previously it was not an easy transition. You know, when you replace prosecutors in a serious case like this, it's a sensitive matter because it you know, it's not easy for a victim to reiterate her story and tell her story to many people. It's not easy, you know, and I want to apologize to the victims for that, but it was necessary that we change the team, you know. So the internal investigation, Chair, is a broader investigation regarding whatever happened in the whole Omotoso matter. It's not just about Ntelwa, you know. Unfortunately, Mr. Sakata is not here because I took this case over from him. He would shed more light as to what happened before I took over this matter. If I'm guilty of anything, I'm guilty of bringing in these three people that, you know, finalized this case. And I intend to make that right. And I intend to make sure that this appeal, you know, is taken, if need be, to the highest court in the land. Thank you, Chair. Unless there's something else that I need to clarify.
Thank you. Thank you, Mr. Madolo. Chair, if I may just also address one of the questions that the Chair raised about the appeal process. Just to be clear that the decision to take, the decisions to prosecute or not to prosecute or to appeal a matter are legally within the prerogative of a director of public prosecutions, not the national director. But you are absolutely correct in terms of the section that you quoted. They work under the control and direction of a national director, but it excludes prosecutorial decision-making. That being the case, when there was an acquittal in this matter, I contacted Barry, Advocate Mr. Madolo, immediately, and respecting the fact that he is the decision maker on appeal. And unlike previous national directors who blurred this line and created lots of problems in the National Prosecuting Authority, I have been very strong in holding the line that as DPPs, I will not interfere in your decision-making processes, but insofar as ensuring all the things you mentioned, the support, ensuring that cases, their proper risk management that we've now put in place, there are a lot of lessons that we've learned from this. But as the national director, I've got to make sure that a prosecution has the best chances of success. And what do I need to do to hold DPPs accountable, as well as to give them the necessary support in cases? In this particular case, once there was an acquittal, I contacted the DPP immediately and I said to him, we are going to set up an outside team of prosecutors from outside of your division to look into this matter, to help you, because ultimately it is a DPP's decision, to help you make a decision on appeal. Not just people from outside, the best prosecutors in the country from outside of the Eastern Cape, but also we will get senior counsel from external to the NPA to help you make this decision. This was something the DPP supported, but it was something that I had said must be put in place, because given the credibility deficit that the Eastern Cape was facing, it was important. And this is not to cast, in fact, the lead prosecutor in this matter had to work with the internal team because, you know, they needed information, etc. So he worked with them. But apart from that, it was a big external team. So that was put in place. The DPP supported it and we moved with that. So in this particular case, the the red flags were certainly raised, but before the change of the team. After the team was raised, as you heard the DPP, there were absolutely no red flags that were raised. The issues of cross-examination, etc., I would think surprised most people, including the DPP, when the judge mentioned it. So it's not like whilst the new team was proceeding, there was any need certainly for the national director to intervene, because there was absolutely no red flags that were raised by the DPP about. But yes, there were problems with the red flags raised with the first team. And we've explained what happened, but to give a little more detail if we need to, just to mention that the application for the mistrial, and Barry, maybe you can help me out in terms of the dates, because I don't have everything right in front of me, but I think it may have been in my notes, I'm not sure, but was in 21 or 22, where the application for the mistrial was brought, specifically on some of the grounds that you mentioned, Chair, that there was the suborning of the witnesses. And it will be useful to read the judgment in that matter, because the application was not granted, because the judge found in that case that the conduct of the prosecutors did not amount to a mistrial. So those matters that were now raised in the main trial, and again, I find myself very constrained, because as the prosecuting authority, we argue and we legally criticize opinions and judgments in our papers. We don't do it in the public. Out of respect for the rule of law, we do not do that. And this puts us in a very difficult situation where I do not want to criticize publicly. But so when we can't explain everything. There's a gap in the understanding. So to be very clear that in that judgment, the application was not granted. And the issues that you mentioned were actually dealt with there. But the judge in the final decision certainly raised that as some of the reasons why she potentially could not decide to what extent the witnesses had been influenced. Now, we have views on that, but I'm not going to say anything more about it because the matter is under appeal. But I'm going to call on Advocate Mthunzi Mahaga, who is the head of our Legal Affairs Division, who is managing the process relating to the appeal, to answer some of the questions relating to the reasonable time issue, etc., which the chair raised. But before I do that, I'm going to call on Advocate Bonnie Curry-Gamwell to deal with some of the issues that have been raised, particularly relating to training and other matters. Bonnie?
Okay, thank you, NDPP Chair and members. If I may proceed, there was a question that was directed at me by the Honourable Paulson related to the killing of Ms. Pamela Makiti. Just to clarify that she was never a witness in the Omotoso matter, and my understanding from the prosecutors in the Eastern Cape was that the police there, the acting provincial commissioner there, has given a different reason as to why she may have been killed, the motive for her killing. I think that there was a request that in respect of the whistleblowing initiative that would be covered by the DG. In respect of training, so this has been a key priority for the NPA since its inception, that we have a training capacity within the NPA, specifically for gender-based violence, which covers all areas of gender-based violence, which is sexual offences, it is the trafficking in persons, it's child justice, it's maintenance, domestic violence as well. So that training capacity is there with specified trainers, both at head office as well as within the various provinces and divisions as well. We have, and this training is scheduled every single year, and prosecutors are then trained, as I said, across the country. The material which we use is updated on an annual basis, where we take into account, when we do the review We take into account all of the various amendments to the GBV legislation, and we make sure that everything is updated. The training, besides the scheduled training that we have every year, there's also ad hoc training that takes place all of the time, where DPPs are allowed to access the trainers to make sure that if there is a need for any assistance, that can be given. Now, following the Omotoso matter, I think it was Honorable Swart, you said we should it's an opportunity to do some reflection, which of course we have done intense reflection. And so what we have now embarked on really is looking at what is our capacity in terms of GBV litigation. We have tried to, and we in fact succeeded in creating pockets of litigation capacity throughout the DPP offices, as I explained when I spoke earlier, when we spoke about prioritization. So there are pockets where we have these GBV vulnerable groups portfolios, where advocates, skilled advocates, resort within the DPP offices that are able to tackle the bigger cases. We also have the same type of capacity throughout our lower courts, where we do the training as I've described before. But upon reflection, we are now going to look at, because there's been a lot of changes in the NPA in respect of capacity. So you might have people that have been transferred or new people that are coming into the system. What we are now going to do is we've created committees within the soccer unit that will look at, for example, how do we enhance victim management even more? How do we, and the second committee to look at how we handle matters such as an Omotoso matter. And the third one, training and competence or capacity of our prosecutors. So that is going to require a skills audit where we look at who are the people that are doing these matters and are they adequately trained? And where we find the gaps, we will immediately address those gaps because we have the capacity to do so. So I think training is probably one of the key areas that we are going to drive even more so now in respect of all of our prosecutors. But we will start with the ones that are specifically dealing with these cases in all of the levels of our courts, so whether it's the lower court or whether it is the high court. So that is a part of what we as the NPA will deal with. There was a question posed by the chair, and I'm not sure, Chair, whether I got you incorrectly, but I understood you to ask that there was a letter that was written by the victims in this matter of Omotoso to the NDPP about the dissatisfaction with the prosecution team. I am not aware of such a letter. What I am aware of is a letter written by the victim, one of the victims, to the office of the NDPP requesting that Mr. Ntelwa actually remain on the case because they have confidence in Mr. Ntelwa. So I just wanted to place that on record as well. Thank you.
Thank you, Bonnie. Chair, if Advocate Mahaga can deal with the legal issues and the processes and the reasonable time that we hope to lodge the application for leave to after all of the processes before that.
Good afternoon, Honorable Chair and Honorable Members. Thank you, NDPP, for the opportunity. I'm on the road to the Eastern Cape, so if I get cut off, please bear with me. I just want to highlight the fact that when you are invoking Section 319, which is a request for the judge to reserve questions of law for consideration by the Supreme Court of Appeal, 319 does not stipulate the time frame. However, 311 and 316, which are ordinary appeals, do stipulate 14 days and 21 days. but we undertook to do so within a reasonable time so that there is no undue delay. But then when counsel went through the transcript and the judgment that was delivered on 2 April 2025, we struggled to identify factual findings that warranted the rejection of the evidence of each witness. And the case of the Supreme Court of Appeal, the judges there made it clear that the prosecution in a case of DPP versus DPP Western Cape versus Skuman and another, it is wrong to craft questions of law for consideration by the Supreme Court of Appeal in the absence of clear factual findings, because you are likely to commit a mistake of construing questions of fact to be questions of law. Then our SC said, or took the view that we supported, to say, let's first seek clarifications on the factual findings so that we finalize our provisional questions of law, which we did on Monday, and the registrar of the High Court in Gqeberha confirmed the receipt thereof. But there was an indication that the Honorable Judge, since he's on retirement, is not available, will only be available next week to respond to us. Now, the important part of it is that we can't commit the same mistake that was committed by prosecutors in the Western Cape in respect of the SCA judgment. And it's clear there. I've made it available to some people who were asking questions as to why, when the judgment was read live on TV, are you still asking for reason? And I said, we're not asking for reasons. We are saying the factual findings are not glaring. If those are clarified, we will then say, you failed, Honorable Judge, with respect to apply the principles or the law into those facts. And the factual findings that we made make us conclude that when you applied the law, you did so wrongly or you misdirected yourself with respect. But there are provisional questions of law that we've crafted. We will then, once we receive that clarification from the Honorable Judge, finalize them and submit them. But the timeline will start kicking in when we receive those factual findings. I'm not sure if there's other issue that I needed to clarify when it comes to the appeal itself.
Thank you, Advocate Mahaga. Can I come to Ms. Tsidi Modise, who will deal with some of the issues relating to proceedings against prosecutors, labor-related issues. Tsidi is the head of our HR Chief Director in the NPA.
Thank you, NDPP, and good morning, Chair and members, honorable members. The question that was raised was relating to the timeframes it takes to do an investigation by law, or prescript requires that it should be finalized within 30 days. And in terms of inquiries, we have 60 days to complete an inquiry once it is set. But having said that, the chairperson of the hearing, once there is a first sitting, has the determination to extend the period, particularly if there was suspension involved. That would address the issue of how long it will take. And there was also a question of protection of employees and the employees and support, employees awareness and support that we give. We have a contract that we enter into with external service providers that provide for wellness and support to the employees. We do proactive support where we do not wait for complaints, but we also have a reactive mechanism systems where whenever an issue is brought to our attention, we then deploy. The reason we use an external service provider, obviously we're not a health and wellness organization. So we are able to access doctors and psychologists and nurses through that program. And as well, we are able to have a national reach in all offices. We do have a limited internal support for those employees that feel that they need support for internally, but it's only limited in terms of that, in that regard. And we also end up doing that online because we cannot reach the whole of the country. But in terms of making sure that prosecutors are supported, it is through the service provider who has a national footprint in all the offices and is able to reach all the prosecutors. We in addition to that, we on a regular basis, we conduct trauma debriefings given our environment that we do with prosecutors to make sure that they are debriefed. And we also give them skills in handling conflict because they work in a environment that is full of conflict. So these are some of the things that we're doing, but we are available and we have made sure that the contract that we enter into or the SLA with the service provider is that they've got to respond within 48 hours whenever an issue is raised for them. I think on the issue of suspension of the prosecutors, Advocate Berry has indicated that we did not suspend them because it is an after effect. The purpose is not going to be served because the investigation is on facts that have already happened. And we have from the labor side working together with the Office for Ethics, OEA, we have set up a team, and we have in that team, we have a person who's full-time placed in the investigation team to make sure that the investigation is finalized as soon as possible. The agreed time is by the middle of June, they would have finished. And by the middle of June, because they had to go through all the transcripts to be able to determine if the prosecutors failed, or as the chair has asked, whether they were deliberate or just incompetence or something happened beyond what we could see. So it is, we need to go through the investigation team needs to go through all the transcripts. And as you know, that was a long trial. So the transcript is very long, but the indication and the commitment is that we will get a report by the middle of June, and which will also make a recommendation in terms of what further action we need to take against one or all of the prosecutors that were involved in that case. But having said that, we also, one of the things that we got is to not to discipline prosecutors for doing their job. And hence we needed to wait, and we needed to have a formal investigation to find out if there was a misconduct, so that we don't create a scare with all the prosecutors to make a decision, because they have to make decisions every day on all the dockets. And if we are going to be on their case and disciplining them for everything that they do, they are going to end up not making decisions. So we're mindful of that. But as I say, the reliance on these investigations is more on the transcripts than on anything else. There was a question about the protection that we offer to the prosecutors. The protection obviously is not given from HR side, but whenever there is a threat, it is reported, and proper measures are put in place to provide VIP protection for them. But also in some instances, you find that the solution is just to temporarily transfer a prosecutor to a safer place, which will then come to us, and we do that. So whenever there is a reported threat, we do react to those threats, and we put measures in place to ensure that the prosecutor is protected. Unless I have missed something, NDPP, I think those were the issues that were raised.
Thank you. Thank you, Sidi, Ms. Mahaga. Modise, can I ask Advocate Mziniati whether there's anything more that NPS would like to add? I have some further responses that I need to deal with. Can I hand over to you if there's anything from your side, any of the NPS colleagues want to add anything to some of the responses?
Good afternoon, Chair and Committee and everybody on the platform. No, NTPP, I've been following the proceedings up to so far, and everything that relates to the NPS, I think, has been sufficiently covered. So I've got nothing to add, Chair and NTPP.
Thank you. I'm going to come back to Bonnie after in a bit about the withdrawals. That was raised by one of the colleagues, as one of the honourable members as well. And Chair, just to say that we have been categorizing because there was a lot of overlaps between the questions. So we've been categorizing and trying to deal with all of the questions. I know there's some that's still outstanding that I will deal with. But if we haven't dealt with any, we would please, if the committee can please remind us. And so we could, there was one that I said, there was one on the OEA, and there was wanting to requesting know more about it and what it's doing. If we can ask that, we will provide its mandate, etc., provide a response on that in writing. I'm going to ask Bonnie to please come in. There was a question about the withdrawals. If you could deal with that before I deal with the outstanding issues.
Thank you, NDPP. The issue of withdrawals, I'm just going, the matters withdrawn, I think that it came from Honorable Sali. It was around the matters that are withdrawn and the matters that are underreported. So in gender-based violence, I'll start with the second part first, which is the underreporting. Underreporting in gender-based violence matters throughout the world, that is a huge issue. And so a lot of work is being done in the prevention sphere by the NPA through its public awareness campaigns with other stakeholders within government, also with civil society, to speak around empowering our people out there to be able to understand the need to report and what is available for them in terms of victim management, in terms of cases, in terms of the criminal justice system for when they do report. But that is an ongoing battle, but it is also a key priority of the NPA and will continue to be so. Just to note that even in the TCC sphere, you know, we've seen an increase in the number of people entering the TCCs, and we would like to think that it is because of this public awareness that we are busy with throughout. In respect of the matters that are withdrawn, matters that are withdrawn can, of course, be enrolled again. So most, and again, I speak in a GBV environment, most of the time, the reason for the withdrawal in the past has been because of DNA. That does not seem to be the case right now. We have introduced a prioritization in respect of the DNA capacity. And so because of that direct link that we now have with the Forensic Science Lab, we have been able to say that we do not have cases anymore that is being withdrawn because of a lack of a report, a DNA report being outstanding. Matters are also withdrawn because often victims, despite receiving psychosocial services around trauma containment and ongoing counseling, often are still not ready to proceed at court. And so we need to always place the victim first, their rights, their dignity must be protected. And so therefore we do at times withdraw as a result of a victim not being ready to proceed. So again, various reasons why matters are withdrawn, but we do try and emphasize the re-enrollment of these matters. When you look at how we engage with our prosecutors during our training, we do emphasize that withdrawals in the GBV sphere must be managed as a priority so that those matters, whatever needs to be done in respect of those matters, are done as soon as possible, and so that those matters can be re-enrolled again. Thank you.
Thank you, Bonnie. Chair, there's some other matters that I want to deal with that have not been covered. Firstly, the question by the Reverend.
Please watch your mic.
Question by the Reverend about there were two aspects I think that haven't been covered. About he said willing to meet victims. It's not just a willingness. I actually reached out through the DPP in the Eastern Cape saying that I wanted to meet with them and to arrange the meeting. The DPP indicated to me that they were at that point not willing to meet with the national director. I also expressed this too when we met CRL. I again, because I know that they have been giving very good support to the victims, again, said that if they could arrange a meeting, we would be very grateful. And the reason is, yes, of course, it's been devastating impact for the victims. And I want to hear them. I want to listen, to really deeply understand how they feel the prosecutors in this matter let them down, how they feel. And so that we want to learn from this. We want to make sure that no victim ever goes through this again. It's hard enough having to face an acquittal. But if the prosecutors actually, re-traumatization is something prosecutors get a lot of training on to make sure that we do not add to the trauma of victims. So I really want to hear so that we can make sure that future victims do not ever experience what they did. The Reverend did speak about an apology. I certainly understand the importance of an apology. We are conducting various investigations, and once those are done, I will certainly look at what the options are in that regard. But I want to understand the victims, and I want to look at it very, very carefully. Right now, there's a legal process, there are various investigations. These must be allowed to take their course. And once the investigations are complete, I will then know exactly how, or certainly consider what the best options are. But right now, we feel the pain of the victims. And I want to say to them here and now is that you've done nothing wrong. And then on the issue of prioritization, we were asked a question. Yes, prioritization is a huge part of the NPA. It is one of our strategic imperatives. And the reason for this is because, well, there are a couple of reasons, but one of them is that we will never be able to prosecute all cases. We have to prioritize to ensure that we prosecute those that make the most impact. So there are various criteria that we consider, but it is important to prioritize. And so what we do is, in the context of prioritization, we've now added, following lessons that we've taken from Omotoso, that in addition to simply submitting reports, all DPPs, Directors of Public Prosecutions, are required to do a thorough risk assessment of every single high-profile or high-impact case to identify all of the risks, whether it relates to capacity, whether it relates to witnesses, whether it relates to security, the evidence. It shouldn't be the evidence, because we should prosecute when we know that we meet the threshold of a reasonable prospects. But to identify all the risks, and then to make sure that there's clear risk mitigation plans. And then from the national office as the national director, I will monitor that and make sure that there is the least possible risk that a high-profile, high-impact case can fail. But DPPs in their divisions, of course, can do it more broadly, but this is with regard to the high-impact cases. It even relates to the issues that you mentioned, Chair, one of the members, about the skills of the prosecutor. Who are the prosecutors? For me to understand the rationale behind selecting certain prosecutors in high-profile matters. Do they have the skills? Have we done certain level of inquiry into whether this will be the best prosecutor? There's no conflicts potentially. So there's a lot of work that's going into all of these matters now. Dealing with, and that actually also addresses the question about, taking action after something is reported in the media. That is certainly not the way we operate. We have already we've put in place a lot of things already to deal with ensuring that high-profile cases have the best chances of success. But we're taking lessons and we're actually strengthening those measures to ensure that it's not about when something ends up in the media that we are reactive. We've got to be proactive in protecting a case and ensuring justice. In terms of the timing of the investigations, we were asked questions about why the investigations into Prosecutor Ntelwa and others were not commenced at the time when the allegations were, the DPP became aware of them, and it's a no-win situation. Damned if you do, damned if you don't. This is a situation where I can almost guarantee you, if at that time we decided to proceed with this investigation into the potential misconduct of prosecutors, when the witnesses and victims still had to testify, I can almost guarantee you we would have been crucified for being insensitive to victims and proceeding with this when in fact we should have waited until they testify. There's no win situation. So we assess the pros and cons and do what we think is in the best interests of the victims. And of course, consulting with them, and I imagine that the DPP would have done all of that work before he and the DNDPP advocate de Kock decided it was in the best interest of the victims to delay that investigation until the end of the state case. So, it's a question of really trying to, there's no good situation. It's really trying to deal with which is the two of, which is the better of very difficult situations. There was a comment about the NPA being insensitive to the working class. I think prosecutors will feel very offended by that. From the outset, I recall from the days of Advocate Piccoli, who was the national director, he always said, we must always have a bias for the poor. And it's something that I have been repeating to prosecutors, to DPPs, that it's the poor that we must have a bias for. The powerful and the rich can have a lot of power, but the poor are the most vulnerable, and they're the ones that we must really take care of. And so we do work with the bias for the poor. On the issue of, there were a number of questions raised and the NPA criticized for that don't deal with the Omotoso matter. I'm not going to deal with that. If there are questions that in writing that could be sent to us, we'd be happy to deal with them. Witness protection, I'll leave to the DG. There was one of the honorable members talked about the gaps in the system. And I think I really appreciate that this was actually raised because, of course, there are huge problems in the criminal justice system. If people want to make the NPA the scapegoat for it, we'll have to deal with it. But I hope that there is a very, very strong realization and that we understand our role and we understand what our mandate is. And I'm not trying to be defensive about the role of the NPA. I'm trying to perhaps create a better understanding of the fact that things start with a docket. It goes through a police process. It comes to the prosecution, and so it goes into a court system. And there are various things that can work or cannot work at various parts of this criminal justice process. The honorable members mentioned the forensic lab issue. This was a matter that was raised at the National Efficiency Enhancing Committee meeting, which is chaired by the Chief Justice and all the heads of court, chief magistrates, regional court presidents attend this, as well as defense, various role players. It's a very, very well-attended meeting where the issue of the problems with forensic, the capacity to deal with forensic analysis and the challenges in some provinces, in particular KwaZulu-Natal, was raised. And these are things that have to be addressed. Otherwise, we're always going to be dealing with the backlogs in our system and various other challenges in the criminal justice system. There was another question raised about the balance between an appeal and deportation. And I know the DG of Justice is on this call. This is not a simple matter. And in fact, the honorable member who raised this in fact, raised issues that conflicted me as the national director. And I'm going to be very candid and open about this and share what I can. Yes, of course, you have an appeal process, and you wouldn't want a Gupta scenario where a person is out of the country and you can't proceed with an appeal. So as the key entities in the JCPS cluster, we came together. So it's not a question of the right hand not knowing what the left hand is doing. The DG of Home Affairs, and I want to be very clear, because again, the NPA is being blamed for what's happening in a deportation process. That is not an NPA process. That is a Home Affairs process, and no one should be blamed for it. It is a legal process. So this is not a prosecution process, but the prosecution supports the Department of Home Affairs to the extent that there may be evidence that needs to be led in that deportation, which is a quasi-judicial process before a magistrate. And that is the support that we give. But there was a meeting between the DG of Home Affairs, the DG of State Security, a representative from State Security, the National Commissioner of Police, the DG of Justice, the DG of Correctional Services. No, it wasn't Correctional Services, it was Home Affairs, and the National Director. When these issues were dealt with, and the legal process is a separate process from the deportation process. And again, there are pros and cons, and I don't want to go into the detail, but the legal process we know will take a very long time, the appeal process. And well, we suspect strongly, let's put it that way, given what we know about accused person with means, these processes will go right up to the Constitutional Court, and an appeal process could potentially take years. And in that process of this appeal, you have a person that the country considers undesirable, and I'm not going to use the words that some of the honorable members used to describe the Mr. Omotoso, but where it clearly reflects the feeling that the country has. So you have a long appeal process where you have a person that's been acquitted, so there is no legal basis to hold a person like that in this country. And there will be an outcry about the long appeal process, and that someone who many of the honorable members have in fact said they regard this person as a threat to women. I'm not saying that. All I'm saying is that is the way the feeling is. So the deportation process has been welcomed by victims. And so that process will continue. It's separate from the appeals process. And when the appeals process is finalized, we will, and there it could be successful, or it could go one of two ways. So in the event that it's successful, we will have to consider what needs to be done in order to ensure that the accused faces justice. But I want to make it very clear that these are very complicated issues, and we're trying to be as transparent and as open as possible with the public so that you understand that these decisions are not made in a vacuum, but these are very complex issues, and we're trying to ensure that we deal with it in the best way possible. Chair, before I deal with the Pretorius issue, you asked about the appeal on the facts. The NPA has made representations. You are correct. The DG is online. The issue of the state being able to appeal on a question of fact has been something that we have been raising for a long, long time. But now that the review of the Criminal Procedure Act is being dealt with in the department, we have made many submissions to the department, and this will certainly be something that we would like Parliament's support on, in terms of strengthening the prosecution hand in order to deal with matters where we think the judge has erred, not just on a question of law, but also with regard to the factual findings. And then with the issue of the appointment of Advocate Pretorius, this matter has received a lot of attention in recent times. The DM himself answered questions in this regard just this week. Just to say that the NPA has been given a task, a very difficult task, which the country is clamoring for justice for those responsible for state capture, which we know brought our country to its knees. As the NPA, we want to try to get the best possible capacity and capability to do this. And we do know that there are some that will want the NPA not to succeed with regard to this. And so we want to bring in the best, but making sure we do it legally and we do not compromise anything with regard to conflicts of interest, etc. So Advocate Pretorius has already worked for a 6-month period in the NPA. This was an extent to renew or to give him another contract for a 6-month period. He's brought on board because of his expertise and knowledge with regard to the evidence in the Zondo Commission. He's not involved in prosecutorial decision-making. He's a strategic case advisor, which will help us actually fast-track cases and move them quickly. So, there's absolutely no question of a conflict of interest that arises. But I do want to say that we are looking into this legal. Advocate Pretorius is being brought on board for that purpose. But we are looking at this matter legally, and our prima facie view at this stage is that even if it's a prosecutor, and it isn't in this case, that this is in fact a red herring, and that is not a conflict of interest. There have been judgments in this regard that we're looking at, and so we're going to get a proper legal opinion on this, and we'll be able to deal with that. It's not arisen because, as I said, it's not our intention to use Zondo Commission officials as prosecutors. That's not what we're doing, but my point is that it's not an issue even if we were, but we're not. So that is the point. That's the response with regard to Advocate Pretorius. And I'm not sure if I am not dealing with, oh yes, and I think I must finally address the issues of the call for the NDPP to stand down. I think that if, as the national director, I was of the view that we're failing in the NPA, and I am failing as a national director, I would be the first one to step down. I am not here to hold office for any reason but to serve the people of this country. And that is why I'm in this position. I have no problem stepping down at all. And I would like to say that I have that level of insight into whether I can do this job or not, and whether I should be in this position or not. I think it would be great if we had a culture in this country where people step down when your integrity was seriously impugned. We have done incredibly good work since I took office. And now, I don't want to sound defensive. I really don't like doing this, but I need to respond to calls that as a national director, I should step down. We took office at the end. I took office at the end of state capture, and we had to turn around a captured institution. We have done incredibly good work. And I know this has got nothing to do with the Omotoso matter, but I'm responding to questions. We have done incredibly good work in turning around the NPA, which is now a professional, well-run, reasonably well-capacitated prosecuting authority that has prosecutors of the highest standards of integrity and professionalism. Of course, you will have prosecutors that don't meet this standard. That happens in every organization. And when that happens, we must make sure that we deal with it in a manner that is fair, in a manner that is swift, and to ensure accountability. And so, to the prosecutors in the NPA, I want to say to you that we are not a failing organization. You are not failing prosecutors. I want to commend all of you for the incredible work you do every day under extremely difficult circumstances. Many of you under protection, prosecuting gangs and some of the most violent criminals in this country. This is something we have to deal with, but certainly at this point in time, I'm incredibly proud of the work that the NPA has done. I have no intention of stepping down. And sure, if, the processes must take its course, but my commitment is to the people of this country and to keep fighting for justice until the last day that I can legally be in office. Thank you, Chair.
Thank you. DG?
Good afternoon, Chair.
Yes.
The DG had to step out of the meeting, but I'm still in attendance and I can answer some of the questions if that's permissible to you and the committee, please.
Proceed, DG, please.
Thank you very much, Chair. Let's deal with the first issue of the minister's and the report sought by the minister. Yes, the minister did seek a report from the NDPP with regard to the Omotoso case, and she was in receipt of a report, and she subsequently sought a meeting with the NDPP and relevant officials to discuss the outcomes of this matter. And of course, the minister has expressed a concern about the case as well and its outcomes. A meeting was held, and there are still ongoing engagements between the NPA and the department regarding this case in particular. Obviously, there's many processes in place, investigations, and the reports on doing an appeal, etc. And so it is understood that the NDPP will provide further reports to update the minister and to deal with the issues that the minister raised in a previous meeting held with the NDPP. That is insofar as the minister's work is concerned. And I think further reports can be made available by the minister and the DG themselves at an appropriate time should the committee so require. Then, Chairperson, there were questions around witness protection and whistleblower protection, which arose in the case or in the instance of Pamela Mabini. And some of it has been answered by the NPA insofar as that specific case is concerned. There's two pieces of legislation, Chair, that we need to take note of. One is the Witness Protection Act, where witnesses in a case are given certain kinds of protection after they after they meet certain requirements, and that is the unit that is currently housed within the NPA. And when it comes to whistleblower protection, we are talking broadly about the Protected Disclosures Act, and you will note that the department has completed some research, consulted on it, and we are now looking at amending legislation to offer broader protection to whistleblowers, but not necessarily only in the criminal justice sense, but also where whistleblowers make information available on all types of crimes. So that process is also underway. On the Criminal Procedure Act, the Law Reform Commission is completing the review of the Criminal Procedure Act. 4 papers were put out for public consultation and was released by the Deputy Minister of Justice together with other members of the GCPS cluster, I think around April or earlier. And the 4 papers relate to arrest, bail, alternative dispute resolution, and non-trial resolutions within the criminal justice process. So while those amendments and comments are coming in, the report will be updated, and we are moving on to areas on the Criminal Procedure Act related to the trial phase and the post-trial phase, such as how do we ensure more efficient and speedy trials, etc. So that work is underway, and we expect the bill to be ready by September 2025. Chair, is there anything else that you wish me to respond to?
No, that's fine. That's fine. I'm not sure if you're aware on the progress on the Section 33 report that was invoked by the minister to the NDPP.
Yeah, that was part of the first response that I made.
Okay, that's
Yes,
fine.
thank
you, DG. Members, I think someone is saying chair. Yes.
No, thanks so much, Chairperson, for the responses from the team from NPA. We heard the responses, but we want to tell Advocate Shamila Batoyi that she will never see mistakes on herself. We, as the country, we are seeing a lot of errors on her side. And we are requesting her nicely to resign as soon as possible. And with regards to the issue of Advocate Pretorius, we have never said that there's anything wrong with the act. We are saying, we've never said the appointments were unlawful. We've said they are ethically repugnant, politically motivated, and represent the textbook definition of conflict of interest. The NPA maybe doesn't understand this, or worse, pretends not to, proves how far the institution have drifted from integrity under Shamila Batoyi compromised leadership. So what happened? The same man that Advocate Batoyi is trying to protect here is an independent actor. He has represented Steinhoff International, FNB, and ENS Africa, all entrenched in corporate crimes and capitalist exploitation. His career has been defined by defending the powerful, and he cannot certainly transform into a crusader for justice. His reappointment is not a legal necessity. It is a strategic placement of a politically safe, elite-friendly insider into the prosecutorial core of our democracy. So we are not protecting anyone in state capture cases as we had her representing here, but we are saying what you are doing is wrong, and Advocate Pretorius is not the only person who can handle those cases. You told us here that we have proper people in the in NPA, proper experienced advocates. Then why are you not using them? Why are you having to choose Advocate Pretorius? And we understand that is not going to prosecution, is not going to be a prosecutor, but to be an advisor is similar as prosecuting for a man who previously led the investigations in the very same cases of Zondo Commission in terms of state capture. So we don't agree with you, and we don't want to be fooled here. We are requesting you to be rational in your thinking and not do what you are trying to do here. Thank you so much.
Thank you, Honorable Mhlala. I will take those as your submissions in relation to the matter at hand. I think the first part, the NDPP has replied on it that she's not going to resign. The second part, I was about to request the NDPP to prepare and submit a comprehensive written report on the issue of the appointment of Advocate Pretorius to the committee. Then we'll look at it closely. Then we'll take it from there. I think, members, thank you very much for...
Chair, before you close, if I may on that.
My hand is up, Chair. I don't know if you saw it.
I didn't see it. Okay, let's do like this. NTPP, can you
just on the point, just to say that Advocate Pretorius has not yet been appointed. There's still a process. So
I'm coming to you, Honorable Nomvalo. Please wait a little bit.
So we haven't yet decided what the process is ongoing. Would you want a report now or in the event that he is appointed?
Yeah, I think
he's currently not in the NPA.
Okay. I think in the event that you appoint Pretorius, you write to submit a written report on it. Honorable Nomvalo.
Yeah, just in 2 minutes, Chairperson. Firstly, I think the narrative that we're always spreading that the NPA is disorganized has also manifested itself here. by the manner in which they were responding to questions. We are used to a concise and a chronological way of responding to questions. The manner in which they've answered to our questions, Chairperson, on its own is a call for concern. We are used to a method wherein members to whom questions have been posed, one, they note down the name of members who have asked those questions. And when they respond, they say, now I'm responding to questions of so and so, Mr. Nomval. So that by the time when your questions are responded to, you also note down, so that if there are questions which have not been responded to, you make a follow-up and you remind the chair that, chair, there are these questions which I've asked or that I've posed, but they have not been responded to. So we are not used to this kind of disorganization that has displayed itself here. Secondly, I think, Chair, you have alluded on the details or on the section under which I asked a question to Advocate Batoyi, Section 22, and you did justice by going into subsections. But I had asked a question about the statutory obligation that she has now as the NDPP. And again, she has given a dismissive response, like a dismissive response like she always does, and like she did on the case of Siniswa Makaka when we were asking her. She says to us that the matter was not brought to her attention, and had it been brought by the DPP, then she was going to intervene. And she says, she goes on to say she didn't want to interfere. There's a difference between interfering and intervening. When you are given a leeway by the statute to intervene, you are not interfering, you are just executing your statutory obligation. Hence, our firm belief that Advocate Batoyi failed to exercise his statutory obligations in this matter from when it started, because this is a prominent matter which was making rounds. It's a prominent matter which was on national television. Now, if you are a responsible and an efficient person, you would have taken advantage of this matter in order for you to showcase your strength, the strength of the institution. Now, this matter has caused a great loss of confidence by the public to the NPA. We just wanted to make this point. Lastly, Chair, you can't dance for your own maturance here. We are the judges as the people. It's us. It's the public that can judge your performance. You can't tell us that you have done good and so on and so forth. Whereas the public has a great feeling of unease about the performance of your institution. And you come with arrogance here. You are telling us that we are not going to resign because we have done good. You took this institution to greater heights. I mean, it's the work on record that should tell us that, not your words from your mouth. We must be seeing that from what we have done in terms of executing your responsibilities. You are failing to do simple cases. I mean, it was an embarrassment that Afroforum took a simple case which the NPA failed to prosecute, an assault case, and Afroforum, a right-wing organization, a racist organization, outshined the NPA. A shame. What a shame is that? And you have the audacity to come to this committee and tell us that, no, you did well. You can't dance for your own maturance here. You can't be the judge in your own case. It's the people who must judge your performance. And we say on record here as the NPA that you have successfully collapsed that institution. You have dismally failed to do your statutory obligations as the NDPP. Thank you very much.
Thank you. Honorable Mvalo will take those as your submissions. Honorable Tsotetsi.
Thank you very much, Chair. You know, Chair, I'm worried about the aspersions that have been cast by, or rather insinuations that have been made by the NDPP when she wants to invoke a reverse psychology strategy on the members of the committee and suggest that perhaps the fact that all of us were saying that we are noting certain degrees of incompetency on her part as a leader of an institutions that we are saying all those who are involved in the organization are incompetent. That is not what we are saying. And the continuous effort on her part to try and act like she's encouraging prosecutors to remain focused in the work that we're doing. Of course, we have noted that indeed there are areas wherein those hardworking prosecutors have outdone themselves. But we are saying the NPA has a challenge of leadership which directly points to her. We are saying that the NPA has subjected the country into a serious embarrassment, that the NPA has presided over the process of undermining the struggle against gender-based violence and femicide, and that as a leader of an institution, it is only fair that she does an honorable thing, like those that have always called for everyone who's leading an institution, when the institution fails decimal, that they must do an honorable thing. We're repeating the same call to her to say, what is wrong with you, NDPP, taking a decision to resign in the face of an embarrassment which you have caused the entire country in the case of Omotoso. That is what we are saying. Now, I think that it's unfair that all these calls, if this institution chair was led by a black person, I can assure you that these calls would have even enjoyed support of some NGOs which are right-winged and so forth. Now, in this country, we are failing to recognize the incompetencies, particularly when they are coming from people with a better card than black. The NDPP has an obligation to fall into her sword. She has failed the struggle against gender-based violence, and that's what we're saying. Thank you, Chair.
Thank you. We'll take those as your submissions. Honorable Nazin Paulson.
Thank you very much, Chairperson. Chairperson, I'd just like to know from Advocate Batoy, since Home Affairs is planning on sending Omotoso back home, is the NPA planning on intervening to ensure that he stays in the country and also at the same time stays out of harm's way where he cannot cause further injury to our women? And also, Chairperson, I notice once again the NPA is dodging the issue of prosecuting those South Africans who go and participate in the genocide of Palestinians. We have a duty as a country to do everything to prevent a genocide. Part of that is prosecuting those who go and participate, and there's prima facie evidence that those people have gone and participated in the genocide. They posted all over social media. If anyone posts a vehicle that he just bought, the SARS would be onto that person to make sure that he pays his taxes. Yeah, someone goes and show on social media how they committed or how they participated in a genocide. They brag about it. And the NPA does nothing. We report these matters to the NPA. They don't investigate. They don't prosecute. They don't care. It is our duty as a country to do everything to prevent a genocide. It's gone so bad now that members of parliament are now becoming criminal to go over there and to go and whitewash apartheid and the genocide.
Chairperson, point of order.
When we report those criminal MPs to the NPA, are they also going to be...
Honorable
No,
person.
man, this guy can wait.
No, wait.
Chairperson, point of order.
A point of order against you. Honorable Swart.
Chairperson, it's very late in the day. I'd request that you rule that aspersions are being made about members of parliament and that we can conclude this matter as quickly as possible. Thank you, Chairperson.
No, maybe I would have thought that you will raise the fact that it is not relative to the issue at hand. So maybe Honorable Paulson, can we request that the NDPP answers in writing?
No, Chairperson, I'm not done yet, Chairperson. And Chairperson, I don't care how late it is. We were elected by the people of this country to represent them 24/7. No, there's no checkout time for MPs.
Point of order, Chairperson.
Wait, members, wait.
Chairperson, all the apartheid denialists are coming for me. You're going to
Honorable
protect me
Paulson,
from
don't
them.
do this.
Protect me from the apartheid denialists. The
Honorable
people that go and are complicit in the genocide of Palestinian people. Protect me from Grinnis Breitenbach and that Steve
Honorable Paulson. Honorable Paulson.
You said my name 4 times. I'm waiting, Chair.
We are quiet, so that's why I'm not sure if you can hear me. I am saying to you, because the question is not relative to the issue we are dealing with today.
We are dealing with the NPA. It's relevant to the NPA.
No, wait, Kaluborum.
No, Chairperson, you are now shielding the NPA.
I'm not shielding.
And the apartheid denialists, you are shielding them. Because they know they're guilty.
They're going to jail. Honorable Paulson, please, listen. I am saying there are a lot of issues that are actually relevant to the NPA. A lot of them. We can raise them until the end of the year. But we're saying what we are going to do. The same thing that we were saying with regard to the issue that was raised by Honorable Mhlala of Advocate Pretorius. Because it's not now relative to the item on the agenda for today's meeting, can they answer that in writing? And that will be shared to all the members to indulge on, including yourself. Because the problem now is that whether your sentiments are right or are wrong, they are now taking us to a different turn of the meeting. What is going to happen now? This matter has been discussed even in the House. So this matter, the House dealt with. I know that even parties who have made submissions of what must happen in regard to what was discussed in the House. So I don't want you to drag this meeting to what has been what has taken place in the House, and I'm sure we're going to receive reports of how the matter is being handled by Parliament. So can we now specifically deal with the issue of what would have been wait on Honorable Mhlala? I said everyone must wait. So that
I thought you were done. That's why I'm not. Okay.
No,
Chairperson, when you're done, could I just
wait.
Have 1 minute to respond?
Wait, Honorable Paulson. So what we're going to do, Honorable Paulson, will allow the NDPP to respond on the deportation issue that we have just raised, which is very important for purposes of this meeting. Because we understand that if Mr. Omotoso is deported, on the other hand, we're in court, we'll have to do an application of extradition and all the strenuous process. So it's a very important question. Now, the issue relating to the prosecution of those who you think they are participated in genocide and stuff, can we allow NPA to do a written response on the matter? And I'm also highlighting that this matter has been dealt with in the House as well. Can we do like that, Honorable Paulson?
Chairperson, we'll wait to hear from the NPA, but I would just like you to remind the Honorable Steve Swart that it doesn't matter what time of the day it is, we were elected to represent the people of this country 24/7. Not part-time, Chairperson. Thank you very much, Chairperson.
That's fine. Honorable Breitenbach, your hand is lowered. We have dealt with this matter.
I'll abide by
wait,
your decision, Chair.
Honorable Mhlala. There are people who raised point of orders before you. Wait. Honorable Breitenbach, the matter is sorted now, ne?
Yes, I abide by your decision, Chair. Thank you.
Thank you very much, Honorable Breitenbach. Honorable Mhlala.
No, Chair, I just want to raise order on your ruling in terms of the question or my input on Pretoria's matter. Earlier, before we started, you promised this meeting that the NPA will respond. Let's allow NPA to respond. If they don't have answers, they will speak for themselves that they don't have answers. Then they will therefore resolve in writing the response. So I don't agree with you when you said to Honorable Paulson that you are including the matter of Honorable Mhlala of Pretoria's. It is also going to be addressed in a form of written response. Let them respond here. We are waiting for these answers. The people are waiting outside there. They want to hear exactly. Yes. The other thing, Chairperson, let the people not be agitated when we are raising questions here. I saw majority of these other parties, the right parties, they now raise hands.
No, Honorable Mhlala.
Instead of just allowing the process to unfold as it's supposed to be. Honorable Paulson is raising a very genuine issue and it answers here. Thank you so much.
That matter. Please. And the NDPP did make a response on the issue of Pretorius and went to an extent that Pretorius is not with the NPA currently. So the matter has been dealt with.
But I came back now, Chairperson.
Let's not do a back and forth, please, Honorable. Please. NTPP, can you touch on the issue of the possible deportation of Mr. Timothy Omotoso?
Chair, I hope you've noted my hand.
You did not raise your hand, you just appeared on the screen.
No, I did, Chair. Just that I don't interject when you speak.
Okay. You are going to do a follow-up, Honorable Mani?
Yes.
Okay, let's take the follow-up. NTPP, can you pause there? Let's take the follow-up so that the NTPP covers both.
Thank you. No, it's actually a parting shot, Chair, from my side, just because the NDPP has confirmed that all these things that we are saying to her is water under the back of the duck and all of that. So I just wanted to confirm to herself, to this meeting, and to the people of South Africa that before the sun sets today, a letter would have landed in Mr. Ramaphosa's office, where we'll be asking for her suspension pending the investigation into her fitness to hold office. We will invoke the relevant sections in the Constitution and in the NPA Act. Thank you very much, Chair.
We'll take that as your submission, Honorable Mani.
Chair, but why was that announcement important, really?
Honorable NTPP.
I have indeed taken note of that, Chair.
Yeah.
Chair, on the issue of the Honorable Paulson's question regarding the deportation and asking the NPA to ensure that he remains in this country pending appeal processes, but that we also ensure that he, as he put it, I hope I wrote it down properly, stays out of harm's way and that he's not. Now, that's not within the mandate of the National Prosecuting Authority. I explained when I mentioned the dilemma of appeal versus deportation earlier on, why there is no win-win situation. It is trying to make the best of a very, very complex situation. And at the end of the day, I think what the people of the country would feel is best for the country in terms of if one has to take note of the way many honorable members have expressed their views concerning Mr. Omotoso. So there's no good situation here. And as I explained, the appeal processes could take years, and it could also end in a success in the appeal being granted or not. And it's another risk. And in that time, there's no way that the NPA can ensure that that Mr. Omotoso legally, and we certainly do things legally, that he is kept, that people are protected from him. Let's put it that way. So we are coordinating within the JCPS cluster and doing what we think will be the better of two difficult situations. And so the Department of Home Affairs is proceeding with its processes, and we are supporting as appropriate. And we will make sure that we expedite the issue to the extent that we can of the appeal. But I can take it no further than that. And I just want to make one point very, very clear, is that the NPA does not investigate except for the very limited mandate of the IDAC. We prosecute only. Thank you, Chair.
Thank you very much, NTPP. Thank you very much, members, for the inputs and that you have forwarded in the meeting. NTPP, we will wish you luck for the appeal, and wishing that you are going to expedite the matter. All we want to see as members of parliament and the representative of the people is justice being done and seen to be done to the victims, which have laid complaints against the church leader, who appears to be a very problematic character in terms of our legal system. I think we bear an obligation to close down and clamp down any form of criminality. We'll wish you luck. Of course, we'll be monitoring the process very closely, for we draw an interest in seeing justice being served. So thank you very much for appearing here. The Department of Justice, which we are going to meet DDGPLA Tuesday next week for a different matter of the TRC, with you and TPP as well Tuesday. We have an appointment with you on the TRC matters. Members, thank you very much for the insightful engagement. Very robust, and trying to solicit relevant answers to the issues that which the entire justice system is facing in South Africa. So thank you very much. Tomorrow, NTPP, I will be attending the funeral of the prosecutor that was assassinated in Mthatha, the Eastern Cape. I'm not sure if there is anyone from the National Office that will be in attendance.
Advocate Mzanyati will be there. Thank you
very much, NTPP. For now, members, colleagues, thank you very much. The meeting is adjourned, and we wish you a very pleasant weekend. Thank you very much. The meeting is adjourned.
Long live the chair. Long live the chair.
Recording stopped.